And then,
Okay, good afternoon, everybody. Welcome to our webinar today around the lobby registry. My name is Omar Dominguez. I am the Director of Government Relations and Sector Development at Vantage Point. And we're just gonna take some couple of moments here while some more people log on. In the meantime, just to let you know that we are going to be using the Q&A function of the webinar. So if you have any comments or questions, please make sure that you write your comments and questions over there. Also to let you know that there's going to be closed captioning in this webinar. So for people that require additional support in being able to engage with this information, we'll have that available, and as a record also for people to share. And also to let you know that we will be recording the webinar today, and there will be materials and follow-up actions after the session today. So again, for folks that are just joining, my name is Omar Dominguez. I'm the Director of Government Relations at Vantage Point, and we are an organization that exists to support the not-for-profit sector and to enhance the leadership and support the leadership of not-for-profit organizations. And it's my great pleasure to welcome you all today. And before we go any further, I would like to acknowledge that we are in the, our offices are in the unceded territory of the Musqueam, the Squamish, and the Tsleil-Waututh Nation. And would like to pay respect to their elders, past and present, for the care of these beautiful lands in which we get to work, live, and play. And so again, I'd like to welcome in this conversation that we're having today, and in collaboration between PLEO, the Pacific Legal Education and Outreach Society, and Vantage Point. We were hearing that there were a lot of interest in understanding more about the lobby registry that came into effect on May 4th. And we talked about putting together this session. So we'd like to, in terms of what PLEO does, really important to be able to ensure that arts, culture, not-for-profit organizations and low-income artists are able to have access to justice and information around the law, and so that they're empowered to exercise their rights and responsibilities under different statutes. And also it's my great pleasure to introduce Martha Rands. Martha is a lawyer that is specializing or has specialized in the legal needs of not-for-profit societies and many artists. I've gotten to know Martha over the last couple of months, and I've been really admiring her absolute commitment to the sector and to many organizations. So really, really grateful to be able to have this this conversation with you today, Martha. And I know that your commitment and your support for the sector is really admirable and commendable, and we need more of that. So thank you for being there. And with that, I would, if you want to take it away, I will be monitoring questions. If you, again, just type them up in the Q&A function, and I'll be happy to relay those questions, and we can follow up afterwards if we don't have specific answers to what you have to, the questions you have today. So thank you.
Great. Thanks, Omar. So hi, everybody. This is part of the PLEO Lunch and Learn series that we've been running for the last, I guess, 8 weeks. And I am your lawyer today. You can play Stump the Lawyer. This is not, however, legal advice. It is legal information. And those of you with specific questions about your organization and whether or not you're covered by the legislation, I won't be answering those. I will, however, answer general questions, as we will probably leave all the questions till the end. I think those of you who sent in questions will see some of them addressed in the course of this presentation. And I would like to thank Grady Merckx from Blake's, who's been my extraordinary support. He's an articling student supporting the work of PLEO over the last few weeks. So thanks, Grady, and I'll blame you for everything. Anyway, I'm going to share the screen now, and we'll be back with questions momentarily, or at the end, rather. Okay, here we go. So I'm going to talk mostly today entirely really about the Lobbyist Transparency Act and its implications for the nonprofit sector. So on May 4th, BC, the legislation that used to be the Lobbyist Registration Act was renamed the Lobbyist Transparency Act. And on May 4th, it came into force. And there it includes and applies to charities and nonprofits that communicate with public office holders, and they need to think about whether or not they are caught by the legislation and thus have to register and provide monthly returns. There is a transition period that was to extend until June 15th of 2020 to file new registration returns or update current registrations. That has been extended to September 15th, 2020 for lobbyists responding to the COVID-19 pandemic. For all intents and purposes, I think that probably just about everybody on this webinar is probably responding in some fashion to COVID-19. So I would read that as giving us some time to really question whether or not we're caught by the legislation. The most significant change for those of you who have some familiarity with this legislation is that they've eliminated the registration exception for organizations conducting less than 100 hours of lobbying activities. Many nonprofits and charities have been engaged in forms of advocacy and lobbying for many years, but few, if any, ever got to 100 hours. So for that reason, many organizations have never registered as lobbyists because that's just not what they were doing, and certainly not 100 hours. Well, that is gone. So now there is an exception I'm going to talk about in a minute, but that means that we have to consider getting a little bit more in-depth into what is lobbying, what is a public office holder, and do we need to register? Also, there's a new requirement to file monthly returns. That means monthly lobbying activity reports. So these are two very significant changes for us to consider. First question, I think, is what is lobbying? And the Act defines lobbying fairly broadly to include communication with a public office holder in an attempt to influence government matters, such as legislative proposals, bills, resolutions, regulations, programs, policies, directives, guidelines, contracts, grants, or financial benefits. That's super broad and covers a wide spectrum of government activity. It also includes arranging a meeting between a public office holder and any other individual for the purpose of attempting to influence any of the above matters. So this really does apply to letter writing, it applies to meetings, it applies to phone calls, presumably interweb experiences, any number of ways that we have to reach and lobby to change legislation or to change policy in government and public office holders. It does not include communications concerning implementation or administration of any program, policy, directive, or guideline with respect to the person or organization doing the communicating. I think I've underlined the word administration. There are many social service and community-based organizations that have contracts for services with government. Conversations with government employees who are responsible for those contracts would fall, in my view, under the administration of a program, policy, directive, or guideline, and thus is not lobbying. So I know that a few of you did send in that question, and I think it's important to really think about, okay, what is it I'm doing here? And a lot of us are in contact with government officials on a regular basis about our contracts for services or our grants. Does the reports say this or that? And we may even be contacted by a higher level public office holder about one aspect of this, for example. So if gaming branch were to contact you and say, we're doing a survey about something, then that would not constitute lobbying. So I put together a few examples here. Holding a meeting, as I said, including by phone, or writing a letter to an MLA to seek a change in law or policy is going to be lobbying. As I've said, it does not include speaking to an employee of the Ministry of Children and Family Development about your contract for services with government, or speaking with BC Housing about the operating agreement you have with BC Housing. An example of lobbying from a case that we found in 2000 I thought was interesting, suggested that organizing a large letter writing campaign on behalf of the disabled that ultimately gained them a seat on a government board to assist in the reorganization of services to the disabled was considered lobbying. So there are a couple of components to this, and I think they're going to be very important, particularly for those of you who are on this call or part of this conversation, who may really need to think about whether or not there's room for a challenge to the application of this legislation, and I'm going to come back to that in a moment. Another example that I thought up, with apologies, I think I've misspelled Selena Robinson's name. The executive director of a housing society attends a meeting with Minister Selena Robinson, organized by Jill Atke, the CEO of the BC Nonprofit Housing Association. The ED tells the story of how they are being affected by non-smoking rules. I just made that up. This is not necessarily true. I just was thinking of a policy that might be something you take up with the minister responsible for housing. And the ED is telling the story of the effect of these new rules. Telling the story of an impact is not lobbying. So another example I might give from our experience, we were looking at the access to records provisions of the Societies Act. I went to a meeting with Carol James, and in that meeting I had with me an community and social service agency from Victoria who told the story of an access to records dispute that arose in their society. She would not be lobbying. I, however, was probably lobbying. Another example of what is not lobbying would be an expert medical doctor who is also part of the meeting with Selena Robinson, talking about the impact of passive smoke on people. That is not lobbying. However, if the expert is there specifically to lobby in some other, perhaps it's advertising rules, and they're there in more than simply an expert capacity, then that could be considered lobbying. So a question that's come up quite a bit as I've been undertaking this review and in light of the questions with the registrations was, is advocacy the same as lobbying? Well, the short answer is no. Though there are a lot of similarities, and in some sense, it's a distinction for some without much of a difference. The Oxford English Dictionary defines advocate as one who pleads, intercedes, or speaks for another, one who argues on behalf of a proposal. And there's nothing in this definition which excludes advocacy for a charitable purpose or limits it to attempting political gains. So you can see it's a very wide definition. And that last sentence is actually a court looking at that definition and clarifying the use of the term advocacy, particularly where charitable purposes are concerned. One of the reasons that advocacy is coming up as a question here is because of the changes to the guidelines from the CRA about what are political activities. For all of you who are part of charities, if you have not already done so, I encourage you to review the new guidance from the Charities Directorate about what are political activities within the meaning of the Income Tax Act, so that you're clear that the kind of advocacy like a letter writing campaign is not going to qualify as political activities unless it's done for a partisan political purpose. So you need to be really clear about why are we doing what we are doing, and what is the impact that the letter writing campaign, that the meeting with the minister is anticipated to have. So advocacy is going to depend, or the application of lobbying is going to depend a lot on what is the outcome that is being sought and what is the purpose of our organization. So I wouldn't say that advocacy and lobbying are the same thing. I would say, though, that for charities in particular, you need to be clear about what the distinction is. And that if you are caught by this legislation and do find that you have to register as a lobbyist, even though you're a registered charity, that ought not to impact or have any role in the Charities Directorate consideration of whether or not you are engaging in political activities. That, however, is something that you probably should be having a conversation with a lawyer about, and particularly for organizations where, or charities where there's quite a bit of engagement with public office holders, you may want to seek legal advice. So the application of the Act depends not just on are you lobbying, it's also, are you lobbying public office holders? So we need to look at the definition of public office holder. It's very broad. Members of the Legislative Assembly and their staffers. Most staff of members of the Legislative Assembly are political appointees. They are not government bureaucrats, so to speak. So we're talking about the constituency assistants, the parliamentary staff of an MLA, officers or employees of the government of BC, most individuals appointed to a governmental office or body, including, say, a crown corporation, officers, directors, or employees of any government corporation as defined in the FAA, such as crown corporations. It does not include judges or justices of the peace. And the registrar has said, has indicated in their, I think it's in the FAQs, that the act does not apply to lobbying of municipal governments or the employees of municipal governments. Once again, when we're talking about speaking to individuals who work in government offices or bodies about our contracts or grants, that is not lobbying. That is, I think, covered by the administration, that is purely related to the administration and implementation of the contract for service or the project that you got a grant for. Some examples, well, are my local MLA, Spencer Chandra Herbert, Provincial Health Officer, Dr. Bonnie Henry, employees of the BC Environmental Assessment Office, as well as, say, the chair of the board of directors of the BC Lottery Corporation, Peter Capel. So, who is considered a lobbyist? Now that we think maybe what we're doing is lobbying, and yes, we are doing that with Selena Robinson, trying to get a change in a rule around smoking that's been added to the RTA, the Residential Tenancy Act. And the LTA defines two types of lobbyists subject to different rules. A consultant lobbyist is an individual who, for payment, I will come back to why I've underlined that in a moment, undertakes to lobby on behalf of a client. An example is Don Stickney, who's a consultant lobbyist with Earnscliffe Strategy Group, who's paid to lobby on behalf of Lyft. And we got all of these names from the registry. You can have a look yourself at who's who in that milieu. An in-house lobbyist is a person who is an employee, officer, or director of an organization who receives a payment for the performance of the person's function and lobbies on behalf of the organization or an affiliate. Okay, so here's two examples. Harsha Walia, who is the executive director of the BC Civil Liberties Association, is paid as part of her job as executive director to lobby on behalf of the BCCLA. And we know this because we found her in the registry. That is why we are speaking about Harsha, and her name may come up again. Also, our friend Omar Dominguez, who, as part of his job, is responsible for government relations. So he is paid by Vantage Point to influence government. There have been 3 letters written that I saw on the website, one to John Horgan, one to Kennedy Stewart, and there was a 3rd letter, and I can't remember who that one was to. Maybe it was to Justin Trudeau. I don't know. I think it might have been. In any event, so Omar would, in fact, have to register as a lobbyist. One question that might arise is whether or not the executive director, Alison Bruin, has to register. Well, that would depend on what her function is in those meetings with government. Is it her function to coordinate the strategy and to do the lobbying, or is that Omar's function? Is her role to perhaps tell the story of how the sector is impacted by some of the decisions made by government? That's where, you know, there may be some leeway there as to whether or not Alison would have to register as a lobbyist. So who is not considered a lobbyist? Well, this is important, and I can't stress this enough. That's why it has its own slide. An unpaid volunteer is not considered a lobbyist, such as an unpaid member of the board of directors. Now, in the earlier slide, there's a reference to director of an organization who is paid. Yes, it is possible that some nonprofits, very few, but some, do remunerate their directors for the function of being directors. The family physicians associations, all the medical society associations, a number of those people are paid directors, as well as some indigenous organizations have a practice of paying their directors. However, charities cannot pay their directors. So they are unpaid volunteer directors, and they do not have to register if they are the signatories to the letters that are written by and sent to John Horgan or whoever in the provincial government. Very, very, very important. So if you are a executive director of a community and social service agency and you have signed a letter, or you want to sign a letter to Minister Horgan, to the Premier John Horgan, then my suggestion is take a moment and think about whether or not the letter actually ought to be signed by the chairperson or the president of the board of directors of the society. If all is lending its name to an advocacy campaign launched by an umbrella organization, it kind of begs the question of whether or not they should have to register as lobbyists. And quite frankly, if there is a way to address this, it is by having the board actually sign these letters. And actually, to my way of thinking, I think there's real value in that. It engages your directors with the important role that is played by seeking changes to policies and practices of government that impact people's lives, which is the main reason why nonprofits and charities are even involved in lobbying in the first place. So there's also a limited exception provided in the new legislative framework. An individual is deemed not to be an in-house lobbyist if the individual is an employee, director, or officer of an organization that has fewer than 6 employees. Remember, employee, director, or officer would be paid individuals. The lobbying by the individual, either alone or together with other individuals, on behalf of the organization or an affiliate of the organization, totals fewer than 50 hours in the preceding 12-month period, unless the primary purpose of the organization is to represent the interests of its members or to promote or oppose issues, and the lobbying by the individual is for that purpose. So small organizations with less than 6 employees that are not involved in 50 hours of lobbying do not have to register as in-house lobbyists. So for a number of smaller nonprofits and charities, they're going to be covered by this. The ones that aren't, that also could be quite small, an example might be Board Voice, which is an advocacy organization on behalf of members of boards and actually does advocate exclusively, arguably, for its membership. It has, I think, 1 part-time staff, but that doesn't mean anything in this context because it's arguably caught by the primary purpose of the organization being to represent the interests of its members or to promote or oppose issues. There is a question about what are the interests of the members, and that would come up in further consideration of this exception. So here's a few things to think about if you're looking at having that exception apply. So we asked the registrar's office about the definition of the word employee, and they advised that all of an organization's employees will count towards calculation of an organization's total number of employees. It makes no difference how many hours they work or how much they are paid. Bear in mind that it's payment here, so this wouldn't include volunteers. They did say, and there will be an FAQ on this, they suggested that contractors are unlikely to be included in the total number of employees. We don't yet have the official word on this, so I would say watch this space. There's a lot of FAQs. It's an excellent site. There's lots of information on it on the website, and we've got a link to it. And there will be further links in the info sheet that will be circulating. But I know that some organizations have very, very few actual employees and are more reliant on contractors, not least of which are many in the arts, where you might have one or two full-time or part-time staff, and the remainder of people who are working for the society are contractors, those involved in the art forms or perhaps just for a festival or something like that. So seasonal workers would also be another one. So I think that there may be some question here for organizations that have a lot of contract staff about the ability to access the exception. And then we get to the last part of the exception, which is the purpose of the society. Is it to represent its members, such as the Federation of Community and Social Services, who might challenge how legislation impacts their members or the policy and practices of the MCFD, that is the Ministry of Children and Family Development? So I think there's an example of an organization that likely would be caught by the and have to register, even if it only had 5 staff and only did under 50 hours of actual lobbying. However, you know, their members might not, and I think that's really important because I know a number of you are actually community and social service agencies that are part of campaigns, but are not driving these campaigns. And so you really do need to think carefully about how you're involved with these campaigns. The other thing that came up, and I'm simply throwing this out there because I know there's a couple of people attending today who have a particular interest in this. I would really query whether the definition of lobbying is actually overbroad here, because if the activity that is undertaken by the charity, and this is only for registered charities, which have to be acting in a manner, their purposes have to be charitable. Part of having charitable purposes is the public benefit of the activities they are pursuing. It sort of begs the question to me whether or not there shouldn't actually be an exemption for registered charities. Because on their face, their entire purpose is public benefit, not the benefit of, you know, we're going to win the contract with government. The advocacy that is undertaken by most community and social service agencies, and indeed many in the nonprofit sector, is not directed at benefit to the organization. It's directed to benefit everybody. It's to feed the hungry. BC food banks come to mind, all food banks. And so, yes, there may be a demand for government to change policy with respect to food security. That being said, they're a registered charity. Their entire raison d'etre is for the public's benefit. So I was thinking about this morning, and again, I would encourage some of you that have an interest in this to maybe ponder whether it might be worth having a conversation around how we might actually challenge its applicability to those who are deeply invested in the public benefit, as opposed to private benefit, which is generally how lobbying works. So I'm just going to take you through what is required by the legislation. There's a registration return. It's fairly straightforward. Name and business address, the organization, the name of the lobbyist. So in the case of Harsha Walia, name, address, etc. And also there's a requirement to disclose contributions by people towards the lobbying activity, and from those donors who have a direct interest in the outcome of the lobbying. Now, again, for those of you who get donations, whether charities or nonprofits, the reality is they're giving you money to end homelessness. They're not giving you money so that Jill Atke can be put on a particular government committee. That's not why, and that's not why the BC MPHA is lobbying in the first place. It's lobbying to end homelessness. So I think there will actually be very little in the way of disclosure required here for many nonprofits and charities. But it will be important to know this, that only those people who've said, here's more than $1,000 so that you can lobby. And I think it would have to be that kind of explicit arrangement in order for you to have to disclose the donor's information. And when you think about that requirement, that is the kind of requirement that really speaks to the purpose of this legislation. And for me, raises the very real issue of why this particular sector that is so very much concerned about public benefits should really be caught and included in this legislation. While there are some organizations that no doubt should, because they are set up for that purpose, associations of various industry associations and such, where their members are going to directly benefit. But in our case, many nonprofits, our members aren't going to directly benefit from anything we do, because our members are our directors, and that's about it. We are advocating for change for tenants, and as a housing society, and we may not have a single tenant. Maybe we have one tenant on our board. So this is a really, I think, open question. Here's an example. Here we pulled Harsha Walia's registration return. Here it is. And it's very simple, very straightforward. The details, the intended outcomes, development of a proposal for government, and associated subject matter, elections, justice and law enforcement, and health. Gifts or benefits provided by the organization, there's none. And here's another example of who is being lobbied, and then who are the lobbyists. So there's a number of names there, and who the in-house lobbyists are for the at BC Civil Liberties Association. It's interesting, there's 1, 2, 3, 4, 5, 6. An organization must also file a monthly return. And you have, in those monthly returns, you have to indicate who you've met with or who you've written letters to, the date of the lobbying, who participated, and the particulars to identify the subject matter of the lobbying. Here's an example. This is the BC Common Ground Alliance. They met with Mike Farnworth, Bruce Ralston, Bonnie Henry, and Selena Robertson. And they advocated on behalf of safe working around underground utilities, the importance of the BC One call center. The outcome is was to develop a proposal, and the subject matter, emergency preparedness, etc. So it's an example. I have one example I created as part of this process, and it's just convenient because it was indicative of an organization that wouldn't be caught. An executive director of a contemporary dance company who signs on to letters advocating to change arts funding policy. Are they lobbying? Yes, if they are communicating with a public office holder in an attempt to influence the development, establishment, amendment, or termination of any program, policy, directive, or guideline of the government of British Columbia. So yes. Are they prima facie a lobbyist? Yep. The executive director of this contemporary dance company is paid, and part of their job is to address or help to change the funding of the arts. Do they qualify for the in-house lobbyist exception? Well, potentially, yeah, because they have fewer than 6 employees. This is not Ballet BC. This is a small dance company of which I could name dozens. And the lobbying being done would definitely come under 50 hours in a year. So in all likelihood, they could apply the exception. And if they had their one of their directors actually sign the letters, then all the better. There would be no question that this would apply to them. Most of all, and very importantly, the purpose of the dance company is the public's appreciation of dance. They don't exist to advocate for policy on dance or policy in the arts. They exist, their sole raison d'etre is the public's appreciation of the arts and probably advancing education about the art form, maybe promoting the industry of dance. But again, it's all with an eye towards public benefit. Particularly in this instance, let's say we're talking about a registered charity. I can't think of a dance organization that would have purposes different, unless they were maybe conceivably the dance center, conceivably CADA, the Canadian Association of Dance Artists. There we might get into a question of what their purpose statements are and the extent to which they are lobbying on behalf of dancers or advocating on behalf of their members, as opposed to providing services to their members. Anyway, so that's my example. And now I think we can take some questions. There's some resources here for everyone to take note of. PacificLegalOutreach.com will have this posted. The law students at lawfornonprofits.ca, lobbyistregistrar.bc, and we'll make available the slide deck and the info sheet in due course. I will now stop sharing. Yay.
Thank you so much, Martha. So much information to go through and some questions that are still, for everybody, they're still unclear, but I'll just try to go through some of the way in which the questions came in. And I'm wondering if you can remember back to the case of the organization in Alberta that you were talking about. Do you know if was the purpose of the letter writing campaign for this organization to have a seat at this table, or was this campaign more broadly and the response was to set up the table?
Yeah, first of all, that case was from 2000 and it involves the municipal tax exemption and the question about whether or not they were, there was a misreading by the court, the lower court, of the word advocacy. It's an interesting case, but there's no other information about it. And I don't think that, I mean, most of the letter writing campaigns that I've seen, the advocacy organization is not seeking a place at the table. They're seeking, they're advocating on behalf of people who are disabled, say. I think there's a very fundamental difference between organizations that are advocating for seats at a table or where there's going to be direct benefits to their members, as opposed to the public benefit of housing the homeless, right? I think there's a qualitative difference rather there. I'm still trying to work out, whether there's room for a challenge here. I don't know. There's a few practitioners I'm going to look forward to speaking to, because I wonder if there isn't another way to go about this. There's a really good reason for lobbyists to register, and there may be a subset of the sector that should be registering. The Fraser Institute is a nonprofit. CCPA is a nonprofit that probably would. But I really do wonder whether, the Horse Council needs to register just because they advocate for their members, but their members are not, I don't know. It really does beg a question here. But again, those would be the organizations where I would say, you might want to get a legal opinion, and really we have to look carefully at what is the nature of the advocacy that you're doing.
I guess I can also add that in addition to getting more information, speaking directly with the registry is a good way to get those answers. And I spoke with them actually briefly this morning, just on some questions around application and registration. And they're keen to hear more on the questions that the sector may have, because and one of the questions that we have later on was the sector consulted on the change of the act, and the answer is no, that I'm aware of.
Yeah.
So
yeah, I think before we as a community simply register, I think we need to really unpack what it is that we are seeking when we are engaging in these kinds of activities, and we should be asking directly the registry whether or not we are caught by the legislation. And that's why I said, I realized this morning as I was really thinking this through, that there's a very big difference between lobbying for a private benefit, right? Than advocating for a public good. And the purposes of a charity have to be for the public benefit, and so there seems to me a bit of a disconnect there.
Yeah, and it was probably that wasn't considered when the act was done. It was really done to deal with, corporate lobbying.
Yeah. And I do also think that you know, there are people in the nonprofit sector who are going to feel very strongly that in order to get credibility in the sector, we're a very significant part of the economy, and we're not treated as if we are as big as forestry. And, you know, one of the advantages to registering as a lobbyist, some would say, is that we are seen to be a part of moving the dial on being recognized by government as an effective voice. And for that, I would say, okay, sure. So maybe we should talk about who will register and who really does play that role in the sector. And I think certainly one could make the argument for the CCPA and Vantage Point and those who genuinely are, this is their reason for being. And certainly it's a big part of the BC Civil Liberties Association, but it's not the whole story here. Mm-hmm. And I think, you know, for a lot of organizations, it's adding one more requirement to an already overstretched administrative burden mm-hmm. on the sector.
Yeah, so I'm looking at the time, and so we have 9 minutes left, and we're not going to be able to get through all of your questions, but please do type them up, send them, because we're going to follow up again on this these questions that our colleagues in the sector have and post them to the registry, because yeah, they probably haven't considered that. But just to go back to some of those questions, and you alluded to this earlier on, Martha. So if people sign on a petition that somebody else wrote, like Imagine Canada, is that considered lobbying?
Well, in this case, the Imagine Canada is lobbying the federal government, and this is provincial legislation that applies to the provincial government only, the province only. And I think that's an important distinction here, yeah. Because when you start looking at the 50 hours, we're not talking about 50 hours of letter writing. We're talking about 50 hours of letter writing and advocacy, supporting advocacy campaigns specifically that are directed to public office holders in the province of BC. Mm-hmm. So our MP maybe, member of parliament, federal member of parliament, Don Davies maybe, but not something that's directed federally. So I would say that's not caught by the legislation, but a petition to signing a petition to add, well, I'm thinking long-term care into the Canada Health Act, but to an equivalent in the provincial setting mm-hmm. would be, would count as lobbying. But then, you know, the 50-hour thing is like, you know, that's a long time. That's a lot of hours, mm-hmm. you know, and are you paid? And again, this is why, you know, who is signing this and why? Is it you? Why is it the executive director or the director of programs? Sure, you've got all that experience, but it isn't part of your job description. And more to the point, there's a board of directors whose job it is to maybe that part of their job is actually in part of governance, particularly in you know, governance boards, not working boards, but even in a working board, it's part of their job to ensure that their society is counted as part of an advocacy campaign.
Mm-hmm. So, of whether communication with public officials. So, for example, if a bunch of organizations issue a public statement, but they don't directly send it to a public official or anybody that falls under this act as being the subject of lobbying, is that something that needs to be reported?
I can't imagine a public statement that isn't intended to be seen by and intended to influence a policy directive or guidance of government. You know, stop homelessness now, get people into hotels now, nationalize, take over hotels that are struggling in order to do X or Y. I would have a hard time saying that, you know, not directly linking it to a particular individual is somehow gonna get you out of that. But again, I would look at very carefully, are there more than 6 employees? Is this more than 50 hours, et cetera? And then I would ask yourselves again, whose name is on that ad, you know? Why isn't it the chair of the board of the society? Because isn't that, and quite frankly, some of our board members have way more, are more interesting to public officials than, you know, the program director of some community and social service agency. For all intents and purposes, those people are never going to meet with public officials. And if they do, the only reason they would is to say, this is what my clients are experiencing. This is, they're telling a story, and that's not lobbying. So I would really query whether or not in their official capacity, anybody should have their name who works for a nonprofit. I mean, to me, it's like, this isn't, there's a very simple way to get out of this. And that is by really thinking about, why am I signing this? And if I'm doing it in my personal capacity, like a petition, you know, I just happen to have a job, then, you know, I sign as a person. I don't need to put my affiliation on the petition. Why is that even relevant if I'm doing it as a private citizen? There, I would have to think very closely, though, of, you know, is my employer okay with me being involved in these kinds of things? You know, there could be issues for some workers in some employment situations. Very few, but I could think of a few.
Yeah,
so.
And I guess important to note that there shouldn't be any barrier for the public dialogue and engaging in conversation.
Yeah. Like if you're not, and if it isn't part of your job, and you want to sign that petition that says end homelessness now, you know, as a private citizen who happens to work for a housing society, you know, I don't know that you should be prevented, but that's also why it should have room for you to say, I'm, you know, signing as a private individual, not as a representative of the association.
Yeah,
or
so
my
maybe
employer.
Suggestion for a
So it's
campaigner.
always, it's going to be an edge. If your employer is very concerned about the application of this legislation, then that's a problem. I think it's going to be an issue where, you know, you've got an executive director who's effectively doing 3 jobs. And yeah, you have more than 6 employees, but really this would be an onerous requirement. It's fairly simple. Like, I don't want to make this out to be some kind of impossible task for the sector to manage. It's just, there's way better things to do with that half hour of the ED's time than having to fill out a report on a monthly basis, when none of what it is doing is even remotely connected to the private benefit of anybody.
Yeah, and so I'm looking at the time, and unfortunately we're at the hour here. And but just I will finalize by saying that please type any questions that you have outstanding. We'll make a list of them. We will follow up with the registry on this session and some of the questions that came up, and potentially have a follow-up conversation directly with the registry and the sector to make sure that if that consultation didn't happen, we go back and say, these are the implications, these are the questions, and that this is how we'd like you to consider the needs of the sector. So I don't know if you have any final thoughts, Martha, just to end the session today.
No, I think that you covered it, and just to thank everybody for participating, and to please tell us what you think, because when Omar and I started this conversation a few weeks ago, you know, we both agreed that a letter ought to go at some point to raise the whatever the questions are.
Mm-hmm. Yeah, and then I'll just finalize by saying, and just an answer to one of the questions again, is that this is about relationships and lobbying to the provincial government. So it doesn't include federal government, it doesn't include regional government agencies and municipal government. So anything that has to do with the provincial government. But with that, again, thank you so much for your participation. This is a conversation that is just beginning with us. So please come and join us and send us your comments and feedback. So thank you much. And I hope that you have a great rest of your day.
Great. Thanks, Omar. Thanks, everybody.